Good afternoon. It's always hard following lunch. But I promise you're going to stay awake. It's going to be a great panel. I'm Katie DeBord, as stated, Vice President of Product Strategy at Disco, and I've got a great panel here today. We're going to take things up a couple notches and stroke our chins, as Kenny said, and opine on the future, and also, have some more conversation about what are these lessons learned from the UK that can translate over, from the US that can translate over to Europe. And so, welcome and enjoy. So I'm first going to have everybody introduce themselves. I'll just go down the line. John, would you mind starting first?
Good afternoon. My name is John Yanchunas. I head the class action practice at a US-based firm, Morgan & Morgan. We have 800 lawyers that have a contingency-only practice. Within my practice group, I manage about 95 lawyers dedicated to class action. Thank you.
Hi, my name's Kenny Henderson. I'm a litigation partner in the London office of CMS. I've got a particular focus on class actions, all type of class actions, data protection, product liability, antitrust. CMS is a full-service firm with the largest footprint in Europe, so we get European coverage.
Hi, I'm Nicole Rosenboom. I'm a principal at Doxera, based here in Amsterdam. I'm a competition economist by background, and I focus on litigation, mostly competition litigation, but even more and more data breaches, and maybe in the future even ESG litigation.
Great. So since you're our local, Nicole, I'm going to start with you first. Why the Netherlands? Why do you think that we're here as opposed to the UK, where this conference has been the past couple of years? And what's happening here in the Netherlands?
Well, a lot. So I think one very practical reason is that due to our great tax regime, a lot of companies are based here. So that's quite beneficiary to especially some people who want to claim, start claims. But on a more serious note, I think we have a very good legal system. I know there was a joke this morning. I was a bit offended about the language. I do think you're driving on the wrong side of the road. I did agree with that. But we have a collective regime as of 2 years now. And a lot of cases have been brought already. That's the new WAMCA, it's called. The majority of that is not competition, but it's privacy, securities, the whole range. You can even sue the government if you like, which people do, in fact. And we will see more and more competition cases coming through that route because the law exists for a longer time, so it becomes more backward-looking, so to say. But there is also a parallel legal route which has been used for years and which will probably be also used in the future in parallel with the collective regime, which is the assigner model, which is not an opt-out, but is used could also be used to book build claims of multiple parties. And I think one very interesting to see is how those two routes are going to develop, especially if there is potentially a claim representative in the collective action regime, so in the WAMCA, but also on the same topic, but potentially on a different level within the value chain, a claim following the assigner model, which brings all these questions about pass-on and how to deal with that coming from two legal regimes. So I'm really looking forward and interesting to see how that will play out.
Kenny, what's the scope of the type of action that can be brought in the Netherlands as opposed to the UK? Can you speak to that a little bit?
Yeah, of course. So, so class actions are typically a question of procedural law, and often the mechanism would not distinguish between the type of claim that could be brought using a particular device. The Netherlands is that way with their relatively new law. I believe the Rule 23 in the US is similar, and in the UK, in 2015 there was a decision by the UK government Parliament to pass a law for an opt-out device, but only for antitrust claims. We also in the UK have we've got a real smorgasbord in the UK, even within the UK, of different procedures for bringing collective proceedings. But the other opt-out device is the representative action mechanism, which was the device used to bring the Lloyd and Google claim, which was rejected by the Supreme Court, but in a manner where the Supreme Court pointed out how that device could be used for types of claims. So even within the UK, we've got a complexity of different types of devices. But looking to the future, your first question to Nicole, why the Netherlands? One of the things I find interesting is these changes happen, through either judicial decisions or through decisions by governments to actually make these hopefully conscious choices, knowing what they're doing.
Yes.
And I do think in Europe there will probably never become like the US, where tort reform will be an election issue. Yeah. Europe probably in a few years will be a lot more knowledgeable. The policymakers will be more knowledgeable, and there will be more at the macro level discussing what do we really want to be doing in this area.
Do you think that, and you kind of alluded to it, the forum shopping that occurs in the United States, do you think that is or is going to be occurring here in Europe as different jurisdictions establish their own rules?
Well, I mean, almost by its nature, would the claimant side go first? So they will pick the device and the jurisdiction that best suits them. And when they have a choice, they'll pick the most suitable and preferable procedure. So if that's within a jurisdiction in Netherlands, if the assignment model works better, they'll do that in a discussion with the funder. So yeah, unless there's only one size fits all, if there's a choice, they will choose whichever best suits them.
And a lot of what we talked about as we've gotten to know each other is whether class actions really are the right avenue for protecting consumers. And we'll talk a little bit more in a bit about some of the lessons learned in the U.S., some of the reasons why certification standards. By the way, full disclosure, I was on the defense side of class action work for many, many years, so I'm going to be a little bit more pro-defense, and John will be my counterweight. But John, what do you think about that? I mean, do you think class actions, from your perspective, are the right mechanisms to bring claims on behalf of consumers? And what do you think the journey is going to be for Europe?
Yes. So, our model of the class action begins in 1937, probably not well known around the world. And the real modern Rule 23 as it exists today was amended or created in 1966. So a lot of the earlier class litigations dealt with social justice issues, the protection of the freedom of speech, or ending segregation. Over the course of time, it began to expand to, securities and antitrust. And actually, I was thinking the other day about my own historical perspective. I was not practicing in 1966, although I was alive. But in 1980, I had the good fortune to go to work for a U.S. district judge, which is the highest level of trial judge in the federal system. And the judge sat in the Southern District of Texas, Houston, which at the time was the fourth largest city. So if you can imagine a very robust business climate, oil companies were based there, many large U.S. banks. And I first began to work on a class action in 1980 as a law clerk, writing an opinion on attorney's fees. And then the rest of my work during those 2 years was in civil rights discrimination cases. A lot of the U.S. perspective or the use of the Rule 23 in the 80s and 90s was really antitrust and securities, and as well as civil rights. And I filed a case against the insurance industry, or an insurance company, which began in the 90s, a whole series of insurance litigation. And I think the securities firms, the Milberg Weiss, LaRock Conklin, which was a spinoff that began in the securities practice, began to look at the consumer side in these insurance cases. And I would say we filed 60 or 70 cases against life insurance companies for the deceptive sale of life insurance. And then lo and behold, discovered that insurance companies for decades had charged African Americans more than whites based upon the color of their skin, and then ran through and corrected that for a number of companies. And I think you saw an expansion of the use of the class action model for consumer claims with the invention of the internet, or the expansion of the internet, because everybody could find a plaintiff. My involvement early in the 90s was because every one of the lawyers in my practice group had an ex-FBI agent. The Federal Bureau of Investigation in the U.S. Trains investigators, agents very well, and we use those to help us develop fact-based cases. And with the advent of the internet, with the flow of information and people being more attuned to what can happen to them, we began to see the expansion of the class action device to advocate consumer-based claims, whether it be faulty hair dryers or washing dryers, automobiles, or in today, which you'll hear from the next panel when I'm speaking, the expansion of the practice to deal with data security and data privacy. And I continue to see that happening. I was thinking the other day too that the reason you see a more robust or expansion and application of Rule 23 is because I think we're somewhat of a litigious society in the U.S., but also through trial and error, we've kind of refined some of the things that you're trying to do in the EU and in the UK, where courts simply have not, the process has not caught up to what it was in the US and what it is today. And again, it's through, the expansion of the rule and its application, refinement through litigation over the decades.
John, can you quickly, just to level set, define the certification standards in the US?
Yeah, so, one of the least recognized, or sometimes people spend the least amount of time, is the issue of adequacy, to ensure that you have an adequate class representative. We don't have the Mr. Merricks. We have the average consumer who sometimes know what happened to them, but they have really a very sophomoric, if at all, understanding of what Rule 23 is. So that takes a lot of education for the class rep. And as I said, with the advent of the expansion of the internet, everybody is a class action lawyer in the U.S., even though they may not have the skill, experience, or the financial depth to carry a case, because we don't use litigation funders. Some parts of some firms do use litigation financing, but not the funding mechanism you see in the UK or the EU. My firm does not do that because of our size, of course. Then, of course, we have the issue of commonality. The class must have claims that are common, whether it be in fact or law. The plaintiff must have, his or her claim must be typical of the class. And then we have, the issue of manageability. So, for instance, personal injury claims are not certifiable because they're not manageable. Each individual within the class would have a different measurement of his or her damage based upon the nature and extent of the injury, although we've seen the rise of the use of 23C4 more and more, which is a single issue certification. That is the certification of and trial of the issue of liability, leaving causation and damages to separate individual litigation.
And of course, you have formation issues as well for consumers. Oftentimes, there's a consumer contract that governs, and in the U.S. we have a ban on class actions under arbitration, and class action waiver bans and arbitration clauses are enforceable. And so you have a whole other issue of formation when you have those issues. Kenny, with the certification standard in the UK and presumably elsewhere, we know it's lower. And we had a conversation about what we think the impact of that lower certification standard might be. And Nicole, I know you want to weigh in on this too. Can we start having that conversation, and what do you think the impact in the UK and Europe is going to be?
Yeah, of course. I'll try and weave in the future as well. So for the certification standard for our antitrust law is lower. In the representative action mechanism, there is only one test, that the parties must have the same interest. That's a commonality test. It's rather than same, similar, related, which is the commonality test. In our antitrust mechanism for the representative action, it is just simply one of the same interest. For the antitrust rule, having the Merricks and MasterCard claim going up to the Supreme Court, there was a 3-2 split decision on the minority rulings from Lords Leggett and Sales. They did express concern about there being a low threshold for certification, because I think in the US there is, some people criticize the certification process in that it's expensive, involves a lot of disclosure, it's a mini trial, but that combined in recent decisions like Walmart and Dukes and Comcast with a rigorous analysis threshold means that it does serve to fill it out. Quite a lot of claims are refused certification. So what I think we will be going on in the journey with a split decision in the Supreme Court is that these issues will be revisited in the UK. The journey that the US has been on in the past decades of having a more robust certification threshold, I expect it will happen in the UK as well.
And Nicole, what about the economics of the actions and the impact of a lower certification standard on the case and how you approach the economics?
Yeah, I think, so I agree with what Kenny said, and in the Netherlands it has to be seen because there are currently 2 cases in the collective regime in which there's also a carriage dispute, so the court is thinking hard, probably, I hope, on if and whom to pick as representative. So we're not there yet, so we're not entirely sure about where the bar is in the Netherlands, but presumably they will be looking at the UK and Canadian system just to get inspiration, let's say. I think if indeed the bar would be the same as in the UK, then you will probably see that there is a sort of a shift in terms of the role and the timings of economic evidence. I think in the morning sessions it was already said that if there's a low bar and there's not a number, like a quantum number in the proceedings at certification, there is a bit of uncertainty to set out first. But also the whole, the disclosure in the UK, but the non-disclosure in the Netherlands and others, and the economic analysis will be probably only happen after certification then. And things like the overcharge analysis in the case of an antitrust proceeding, which could also impact the dynamics around settlement, because you can, settlements can happen at any point, but hopefully they are informed, and they can be informed by economic evidence from both parties, frankly. But if that enters later in the proceedings, that might also mean that settlement might also happen later in the proceedings. And there is a question of whether that's the most cost-efficient way to deal with these cases.
Can I just pick up briefly one point around settlement dynamic as well? So one of the nuance and little sentences and rules make massive impacts to incentives and how parties behave. Exactly. And I'm sure many people in the room know this, but not everybody probably will know, that under the UK competition regime, if a matter goes to trial and there's an award of damages, any undistributed sums don't revert to the defendant. Any undistributed sums go to the Access to Justice Foundation, which is very laudable. If there is a settlement, then the rules provide that as long as it is fair and equitable, elements can revert to the defendant. And in circumstances where there's going to be very large sums not distributed, for in-house counsel, that creates a dilemma, where you look at the anticipated distribution level and you have to make your decisions around settlement at that, framed around that, which I don't think is a good system, because settlement pressure should be correlated to the merits of the case, not as to idiosyncrasies in the rules. So again, I do think that as we evolve as jurisdictions, we will look back at these incentives and say, well, maybe if we should tweak bits here and there.
I just one other thought while you were talking. Being a competition economist, I also spot where there is room for competition, and there was a carriage dispute with trucks in the UK. There was a carriage dispute now with the claims against Apple. I'm wondering that even though the system might then say there's a low bar for certification, if there are multiple parties, multiple representatives, doesn't that create some sort of competitive pressure between those parties to speed up their game, basically? So it's no longer only about meeting the threshold of, is this a claim that could be brought collectively rather than individually? But aren't those entities forced almost by the system of showing that their claim and the way they're structured and the way they want to do the analysis and what economic evidence and data they're going to rely on is better than their competitors? basically. So isn't it solved in
Well,
such?
I think that aspect of competition is a good thing in terms of any tribunal or court choosing between which is the better alternative. Just the point I was making was purely on the defendant side as to their game theory of considering settlement is influenced by distribution levels as opposed to merits, which I think can only be amended by a change in the rules.
John, I'm going to throw a surprise one at you. What do you think from the U.S., maybe the top 3 things that should be considered? Maybe they're good incentives or bad incentives in the U.S. for either bringing class action claims, settling them, or defending them through certification. Can you identify some of those incentives that we have?
Yeah, so, I think of the class action device as providing access to judgment. And I'm speaking I'm away from the competition and the securities, but more to the consumer types claims, where you're dealing with claims that are small in number, $40 US or 40 euro, which consumers wouldn't ordinarily bring, right? And there's some complaints in the U.S. about, well, I only got $10. Well, it's $10 you would have not gotten had there not been a class action device. So, when I look at whether or not to take a claim, it's a question of, one, can I try that claim if I were to have only that individual case, even if it was only a $10 recovery? Because if you cannot try the case as an individual claim, well, then you're not going to be able to certify that, much less try that case. And in the U.S., very few class cases that are certified ever tried. In large measure, that's because of the considerable leverage that a class action brings to any company facing a certified class at trial. Also, a lot of lawyers haven't tried cases in the U.S. because the trial is kind of a diminishing creature based upon the increase of mediation, which results in settlements and, of course, arbitration. So in my career, I've only tried 5 cases, 5 class cases. So, and I'm probably on the upper scale of those lawyers who've tried a lot. So that's what I tend to look for. And then I look for cases that have some appeal to a judge. So as you can imagine, we have some cases that never should have been brought as class cases. The short fill on a Starbucks coffee, the foot-long hot dog, the foot-long sandwiches at only 11 inches. I mean, heavens forbid. Those cases never should have been brought. They were brought by very inexperienced lawyers who thought they were smart and they weren't. And it unfortunately ruins, the practice for the rest of us, because you get judges who think, oh, here's another short fill on a Starbucks cup. So I try to bring cases that are persuasive, that have an appeal. And we're seeing more and more lawyers think about that, and we're seeing the class action device being used more and more to address social issues or issues which affect people in the environment. That was one of the things that I should have mentioned earlier, where I see a massive expansion. We have an opioid crisis in the U.S., hopefully not here, and I could not imagine a class action being brought. I filed a number of cases on behalf of some small counties and cities in West Virginia, which is a very poor state in the U.S., decimated by the opioid litigation. But the court found there was a need to address that and let one judge resolve the entire problem across the country. When you think about that, that's almost giving to that one individual a tremendous amount of power, but also burden. So through the class action device, they're trying to address, a real societal injury and damage.
Yeah, thank you.
I had a brief comment on the access to justice point, and I think what will happen in Europe in the next few years will be telling, and key in that is for class actions seeking damages as opposed to behavioural change or injunctive relief, the key point will be the distribution phase and how much is distributed to class members, because I don't profess to be an expert, but I think there was a Federal Trade Commission report a couple of years ago which looked at the distribution levels in consumer class actions in the US, and it found that the mean distribution level was 9%, that's 0.9%. And if we have that in Europe, if we have that level of distribution in Europe. And of course, this is only an issue for opt-out class actions. For an opt-in, the participants have elected to be in, but an opt-out is delayed opt-in. It's opt-in at the distribution phase. And if we have those very, very similarly low levels of distribution, it does raise a question over the access to justice argument, because it is access to justice for a very small portion, but you only know at the very end.
Right, and I would say if you spoke to Cam Azari or Steve Weisbrot, who spoke earlier on a panel, we're constantly dealing with claims rates. I mean, judges who approve settlements want to know what claims rates in similar cases have been, and it's just reaching the American consumer who's in a class to say, we have money to distribute. You know, I've given, because of the inability to, and the desire not to return it back to the defendant, we've given people more money because we've increased their claims. So the defendant hasn't benefited, although, you know, we do have there are claims, based claims, and I have a very good advocate on the other side, and he knows what my position is on those. I tend to deal with a common fund. I want the money to be paid by the defendant and either to go to the claimants, even in larger measure than they would have otherwise received, because their damages may not be $10,000, but they've received $10,000, or to give it to an organization through a cypre, which delivers legal services to the poor.
I'll be honest, I'm guilty of being that person who gets the notice that I'm part of a class and deleting the email because it's $8 and it's not
I always fill them out, even
You
$5 or
do.
$10. Absolutely, because you know, for one thing, I believe I have an obligation as a citizen to ensure that the class action device is vibrant and deals with access to judgment. Because otherwise, without it, you wouldn't find anybody suing for $10. And if that company gained that $10 through some type of misdeed or unlawful conduct, well, the process should mandate that it be given back to the consumer, and the class action device is the only way. And last year, the Supreme Court of the United States decided that the FTC, the Federal Trade Commission, didn't have the power to get money for consumers through unlawful activity, an abhorrent decision. So now the class action device and those who are on my side of the V, the plaintiff side, serve a greater societal purpose.
Yeah, well, you've convinced me. I'll do it next time.
I'm a big advocate, obviously, for what I do. I'm very passionate.
Kenny, you mentioned tort reform. I mean, what kind of legislation do you see potentially coming down the pike on the other side of the Atlantic?
Well, big news in the last month to 2 months was the European Parliament's adoption of potential regulation of litigation funding. So that is a big area. Of course, not impacting the UK post-Brexit, but we can't ignore that. So that'll be a future battleground, no doubt, in Europe and in the UK. I think, the way things currently are in Europe, the pendulum is very much in the claimant side. You know, we've got the Representative Action Directive. A week ago today, the European Parliament adopted the Corporate Sustainability Due Diligence Directive, which is a bit of a mouthful, but in effect what it does is it converts a lot of soft law international treaty obligations into hard law and gives direct causes of action to people to sue under those laws, including with extraterritorial effect. And it's going to bring a lot of teeth to the S element of ESG. We're going to get a lot more labour law claims, transnational tort claims being brought in Europe. So the pendulum is swinging that way. I would expect in the coming years, maybe it'll swing the other way. But it's a pendulum, it always moves. So.
Right. Nicole, one thing that came up that I wanted to talk to you about was, I think it was John mentioned social, the social type claims. And what are you seeing with respect to ESG claims?
Well, I think in terms of claims, it's very much declaratory at this stage. So we saw a few claims, at least in the Netherlands, against Shell, for instance, for speeding up their acting, getting to their net zero or to their emission targets. But that's so far has only been to stimulate, if I want to use that word, firms to act or stop certain behavior. We haven't, at least to my knowledge, seen any damaged claims. I think in the future, also from what Kenny just said, but also more as a sort of mis-selling claims in terms of greenwashing, we can expect claims to arise. So for instance, if you're a consumer, because they could be B2B, but probably they're more likely to be coming from consumers. So let's say you're buying a certain thing, a certain product, which you like because of the functionalities, but also because it says on the label this is made in an environmental friendly way, or for every unit you buy, we planted 3 in Africa, or something like that. And then it turns out not to be true, and hence greenwashing. And in a sense, again, also with antitrust claims, you can compare the actual situation of the consumer buying the product at a certain price and compare it to the counterfactual of what would that product have cost without that green element. So what would the gray version of that product would have been? And the difference between those two is the overcharge in antitrust terms, but it's applicable to greenwashing as well. And I mean, it's really the next frontier in the sense of the whole development of the market, but I really think that in the next few years, we'll get to that as well.
What about, I mean, I know we're going to be touching on this, so I don't want to go really deep into this, but what about database claims?
Well, I would say if you're talking about next frontiers, database claims is probably one before ESG. So, I mean, originally we started with whole 101, so the cartel prohibition follow-on claims. That moved to 102, that is the European law. That is now slipping into privacy in Germany, also in the combination of the 102, but also as a privacy or data breach alone. And that could be simply data breaches of, like, as a firm, you had the wrong software package, you get hacked. Or the one that I find more interesting from an economics point of view is the unauthorized collection or use of data. This is going to be, especially again from an economics perspective, very interesting field to watch, because it depends on the legal standards, so whether it's compensatory or punitive, for instance, what the value of the data in question is. And in the Netherlands so far, we saw a few cases, so Salesforce, Oracle, which hasn't made it to certification, but is now under appeal, I understand, and where they just said, we're going to claim for, I don't know, I don't remember the amount, but let's say you're 100 euros per person. I mean, that is so much far from the economic value of the data in hand. So I really hope to see that what is really common practice now in competition litigation, the overcharge, doing a before-after method. I think most lawyers will know this by now, that that's the common ground in defendant and claimant side. I really hope we see an evolution also in quantification methods for data breaches, because there are loads of methods. So let's not just put a label of 100 euros or 200 euros or whatever an amount, but really base it on the data and the value of the data at hand.
That's why we need people like you.
I hope so.
John, what do you think the next frontier is in the U.S.?
Well, it's somewhat of the current to where it's going, and I think, as you just mentioned, it's data privacy. I speak on that on the next panel, but a good part of my practice today is dealing with data privacy. I began that practice in 1999 with a case against DoubleClick, which would place cookies on your hard drive at a time when hard drives were, still the main function of a computer, but they were very limited. So the more cookies you had, the slower your computer would process. And we had to borrow from a common law claim of trespass to property to anchor that claim and to settle it. But DoubleClick had no money. The internet was not the economic marketplace that it is today. And over the course of several decades, we've continued to deal with now data breaches. And I was telling some members of the audience, I settled the Capital One data breach case for 190 million US, 98 million people. We settled 147.5 million people. Equifax, 356 million, but a combined value of 1.6 billion. Yahoo was 2.9 billion worldwide, 200 million US that we settled for 117.5 million. So a lot of my practice has been in that area, but it's expanded to data misuse.
Yeah.
And a good part of my practice today is dealing with companies who collected information, didn't quite tell consumers why they were collecting it, and are using it in ways in which consumers did not consent. So over the next couple of years, you're going to see some really interesting litigation coming mainly out of California, where big tech is based, Google, Facebook, which I've sued and settled before, now called Meta, which we're suing, Twitter, Oracle, and I don't think there's a company that deals with data in a way that I don't have a present case against. Mm-hmm. So that kind of tells you how abusive, from the plaintiff's perspective, and my editorial comment, that the practice is in the U.S. and, quite frankly, in the world. What they do in the U.S., they do in the world. They don't change it because we cross the border or cross the Atlantic or Pacific.
Well, I want to leave room for some questions. So I'm going to ask you guys a couple of tail-end questions. Kenny, let's start with you. Just in 2023, because we've been talking kind of, broad future plans, but what do you think is going to happen in 2023 on the European UK side of things?
Well, I've covered a couple of points already. I think I agree with Nicole. I think on greenwashing, the focus will be more on product-level advertising. There will be some investment, corporate-level statements that the corporates make about themselves, but there'll be a real focus, I think, on greenwashing claims, maybe akin to false advertising claims in the US that haven't really taken off in Europe so far. But really, I think 2023 is where businesses should also be getting ready and getting more aware in Europe that these risks are becoming tangible, and that the journey for in-house lawyers is different. The majority of claims in the Competition Appeals Tribunal, opt-out class actions, are now standalone claims, not follow-on claims. Mm-hmm. The journey used to be linear. You'd have a regulatory stage, and then you'd have litigation. There'd be plenty of time to get ready and master the facts. Now, innovative claimant law firms are bringing claims much sooner, much earlier. There's a rush to the courthouse. They want to try and position themselves for any carriage dispute they may be facing, and that has an impact on how corporates have to prepare as well. So maybe it's not a prediction, but it's a recommendation.
Yeah.
Is to get ready.
That's okay. That works. Nicole, what about you?
I'm wondering, I think in the context of foreign shopping that you mentioned, I think like John said, whatever happens in the US happens in the rest of the world, which I probably agree with you. I think in Europe we see a bit that whatever happens in the UK we see in the mainland. So Brexit has been unhelpful, maybe, in that context.
Just a bit.
Sorry?
Just a bit.
A bit, yeah. Just to give one example. But I think what it does mean post-Brexit is that you probably see that, for instance, in the Netherlands, but also Germany is a candidate for that you see an opt-out claim in the Netherlands on behalf of the Dutch consumers, then opt-in for all consumers in the rest of the member states, and then in parallel a separate claim run in the UK. And that way you cover Europe as a whole, as in the good old days, I would say. But you need two parallel claims that run together, so to say. So the same matter, same representative aspect, same class, but run as parallel claims simply because of the system.
And there's nothing that stops people from doing that's amazing.
I hope it's, I'm a bit biased, you get that right?
Yeah.
I hope that's the future for the Netherlands.
Yeah. Interesting. John?
So, one of the things that I've seen more and more is the use of the class action device to address, again, societal problems. We have, for decades, made certain chemicals, the forever chemicals, a fire retardant, with the short name PFOA. It's carcinogenic. There's no acceptable level, and it's in a lot of our products, and including our groundwater. So I have a couple of environmental cases against companies, one French, Saint-Gobain, that use that fire retardant in certain products. And you're seeing more and more environmental litigation being used through Rule 23. And then also the use of Rule 23 in attacking the problem with the way social media has affected children. Right now, just focused on children. We have a number of children, maybe as a result of COVID, but who committed suicide, who developed certain disorders because of their life is focused on TikTok, Facebook. There's a multi-district litigation case now before Judge Gonzalez-Rogers in Oakland against Meta, in the way in which Meta used algorithms to encourage children to come back and stay in the universe and through likes to continue to attract them. And any number of children have committed suicide and have disorders. It's out there. You know, my firm is involved in that, and I think you're going to see more and more the use of the class action device. We're looking at some haste-based forums that encourage or facilitate young men to spew out hate, racism. And if you look at some of the mass murders that we've had in the last couple of years, you find some very common denominators. Young men, white, and typically what they said on a social media platform was a predictor of what they were going to do. This was all out there, and they sometimes would film it while they were actually in the act of killing people, young kids. So, you know, we're doing some investigation. There is some protections in Congress about that. But I think more and more lawyers are thinking, well, how can we change behavior? How can we make society better? And, you know, that's the proud part of what we do. Because it's not being done for the money. It's being done because of the societal harm in trying to cure that.
Mm-hmm. Yeah, that's great. That's great. Well, why don't you guys give me one key takeaway that you'd like people to walk away with? You know, and it may be the lessons learned, you know, from the U.S. to the U.K. and where we hope the UK and Europe goes with respect to class actions. And John, what I guess I would like for you to focus on is what are the bad parts of the US? And I'm going to stop because I just saw the sign. Do we have any questions? Sorry, I thought it was going to be back there. All right, well then, John, I'm going to ask you to answer that question in 30 seconds or less. What are the bad parts about the U.S. that you think that people here should be thinking about as they progress in this journey?
Well, because I think Comcast and Dukes tried to put the brake on this, was the abuse of the class action device. We had drive-by class certifications in certain state courts where judges were maybe friendly with the lawyer who filed the case and would certify a case without really getting into an analysis of the facts, kind of I don't want to say the mini trial, but kind of peek under the tent. And a lot of that abuse is being tamped down, but we still have lawyers who because they can do so, they can file a filing fee, and they can file a case that they really shouldn't be filing. But they see, you know, the money being made by the successful practitioner, and they want to replicate that in their own practice. So we see a lot of cases being filed for mislabeling of food, all natural, low sugar, nutritious, things that are, maybe they're not puffery, maybe they really are deceptive, but that's not really going to move the needle for the judges who hear those cases. And you know, I try to stay away from that. I try to mentor as many young lawyers as I can to, you know, talk to me before you file something, and I won't take the case. I just want to help you, help us.
Something tells me all three of you guys would be good mentors. That is all we have. Thank you very much for being such an attentive audience.